of the least understood concepts in design and construction is the concept of betterment. And when we talk about betterment, what we're talking about is a damages measurement. And it's not something that people really think much about, but to oversimplify greatly, you really have two things to be concerned about with claims. One is liability or entitlement on this side. Did the person run the red light or not? Did they violate the standard or not? Have they done something that makes them negligent or subject to liability for one reason or another? And then on the other side is, now, are there any damages that are recoverable that flow from that wrong act? And then more specifically, if there are damages, how do you measure them? So you can run a red light and not get into a car accident, and you will have satisfied the liability component, the entitlement component. You will have done something wrong, but there's no damages, right? Because there's no car crash. But if you do have the accident with the crash, then the question is, how do you measure? What is the quantum of damages that is recoverable? And this is something that there's quite a lot of standards in every state in the United States that are going to take a slightly different take on this. But generally speaking, in contract law, there is a principle where the courts don't want to allow one party to be unjustly enriched. In other words, if you take the victim, the non-breaching party, the person that didn't commit design malpractice or didn't breach the contract for one reason or another, take the victim, take the non-breaching party, and the law is never going to want to measure their damages in such a way that they would be in a better position than if there was no breach, right? So the non-breaching party is supposed to be put in the same position that they would have been in financially as if there had been no breach. That is sort of the prevailing wisdom, the prevailing standard that is imbued throughout most of the measures of damages for contract claims and just to a lesser extent certain other kinds of claims in the United States when you are measuring damages. And so where the betterment rule comes up is in a number of contexts, but two in particular come to mind. One is if you have a design or construction project where there is a construction defect or a design defect, and the owner goes and fixes the problem by giving themselves an upgrade. So, if originally the building was designed with a Ford HVAC system, and the owner, because of some breach of contract, some construction defect, some design defect, needs to replace the HVAC system, if they upgrade it to a Tesla HVAC system, you can see designers and contractors raising a betterment defense saying that you are taking advantage of the breach and you are becoming unjustly enriched at my expense, and therefore we should measure the amount of money that you can recover in a claim against me on account of my breach, not by me owing you the Tesla HVAC system. You only paid for, you only required the design to originally to be a Ford HVAC system, and so you're getting betterment at my expense. So that's one area where it comes up. But what I think is the more interesting area and where I want to focus a little bit more today is when we're talking about architectural and engineering omissions. Okay, that's going to be my focus for a few minutes. Now, I'm not talking about architectural or engineering errors. And this is a critical distinction, the distinction between errors and omissions. An error is something that is just wrong, it doesn't add any value, it's something that needs to be corrected. Omissions, when we're talking about the work of a design professional, is really something that is left out of the design. Okay, and so whenever I'm negotiating a contract and I have a betterment clause in there, usually the other side will start raising objections, and I'll say this doesn't relate to errors, this relates to omissions. And so I'll give a silly example, just to make it a little bit more accessible for everyone. If you have an architect that designed a building and on the hardware schedule, they neglected to include doorknobs, right? They omitted doorknobs. And so, the doorknobs were not priced. And when the construction's ongoing and the owner and the contractor realizes that the doorknobs are omitted, maybe there's a change order to the construction contract, and the question is who pays for them? Well, here is where an architect or an engineer would raise a betterment defense, and they'd say that you always needed doorknobs. If you're gonna have a building and it's gonna be filled full of people with arms and hands that are gonna be opening doors, the owner always needed to pay for doorknobs. And the fact that the architect neglected to include them on the hardware schedule, the fact that there is that omission, does not mean that the owner, gets a free lunch. It doesn't mean that all of a sudden it becomes the architect or engineer's obligation to pay for that item, because insofar as the owner always needed it, then they always needed to pay for it. Now, there is some nuance here, of course, right? Because if an architect or an engineer omits something in their design that's going to be sealed up in a wall, and the omission is not caught until the wall is already sealed up, you've got the in and the out costs of opening up the wall and closing it back up again. And so it's not always perfectly clear that if a design professional omits something from the design, they can just, dust their hands and say, it's, the owner's got to pay for it. There's nuance. Another area where there's nuance is if you have increased prices from the time when the design was first issued, and priced, versus when the omission is caught. And one good example is increased commodity prices like steel. So if a steel beam was omitted 6 months ago from the design, and it's something that the owner always needed to pay for, then it's something that the owner always needed to pay for. It shouldn't get a windfall. But if the price of steel has doubled in the last 6 months, there may be some incremental aspect of the extra cost that would fall upon the architect or engineer because of their omission to include the steel beam in the design at a time when it could have been procured for less expense. And so, sometimes you will see in a design contract, an agreement between a design professional and an owner, language something to the effect of, if due to a violation of the standard of care by the design professional, a required item or component of the project is omitted from the construction documents, the design professional shall not be responsible for paying for the cost required to add the item or component to the project, to the extent that that item or component, would have been required and included, in the original construction documents in the original budget, and sometimes you'll see these clauses go on to say, and in no event will the design professional be responsible for any cost or expense that provides betterment or upgrades or enhances the value of the project. Now this is, again, when you see this, sometimes, one party will say this doesn't make sense. They start redlining it, they start changing it, and then you say, this is about omissions, this is not about errors, and it's something that they understand a little bit more about why, maybe it makes sense to have that kind of a contract clause, in the document. Now, even if you don't have something like that in the contract, because the guiding principle in most states, and I obviously haven't researched them all, but the guiding principle in most states for damage measurements is, again, no windfalls. You don't want to put the non-breaching party, the victim, in a better position that they would have been in had there been no breach. Even if you don't have a contract clause like that, if you want to go the long way around the block, you can probably take all the case law from a state and their general principles, and you can, pull out their jury instructions, and you could probably make an argument to a judge if there is an instance where one party is trying to, achieve a betterment at the expense of the other party, to say, Judge, look at this body of law. Clearly, the windfall is not warranted, but that's a little bit difficult at times because judges typically don't know a lot about design and construction. They typically don't understand the difference between the obligations of a design professional. They don't understand things like contractors are responsible for means and methods, and sometimes judges can get this wrong. So, there are times where it makes sense to try to include, some clause in an agreement between an owner and an architect, or an owner or an engineer, that addresses betterment. Now, Illinois, fortunately, is one of the very few states that has a pretty darn good case on the betterment doctrine. And so rather than having to construct this more elaborate argument, if you're in Illinois and you're raising a betterment defense, you're going to call out to the judge the case of St. Joseph Hospital versus Corbetta, which is a decision that should, be known, by heart by every design and construction attorney in Illinois. And in that case, the contractor installed paneling that was specified by the architect, and it wasn't until sometime later that it was determined that the paneling was not code compliant. So the owner had to tear it out and install, more expensive paneling. And one of the issues in the case, and it's a very confusing case that rambles on for 40 or 50 pages, one of the issues was, who pays for this? Is this an upgrade? And, the court ultimately said that, well, there's no free lunch in design and construction, to the extent that the owner always needed to have, fireproof panels that were code compliant. They always needed them. They should pay for them. And then there was a lot of nuance about, what about the cost of tearing out what was wrong in the first instance. But the point is in Illinois, you have this good case. It is a little bit easier to bring the Betterment doctrine to the attention of a judge that might not understand the issue very well. But that's the essence of Betterment. I like to call it the no free lunch rule. It's not about liability. It's not about entitlement. It's not about whether or not someone did something wrong. Betterment is typically raised as a defense when somebody wants to argue that the way the other party is measuring the damages claim that is being asserted against me is incorrect, because it gives them that windfall. It gives them the ability to be in a better position than had I not breached the contract or committed the design malpractice or did whatever it is incorrectly that is leading to the claim.